Hi all, welcome to another edition of Masterclass with Strata. I am Saloni, the Chief of Staff at Strata. Today I have Nikhil and Niranjan with me. They are from Yellow. I will have Nikhil and Niranjan introduce themselves. Nikhil, please go ahead.
Perfect. I'm Nikhil. I'm one of the co-founders at Yellow. I'm a chartered accountant by profession, been in the estate planning space for the last 10-15 years. My last stint was with IFL, where I was taking care of the South Estate planning practice.
Hi Saloni, good to be here. I'm Niranjan, I'm the other co-founder at Yellow. And while Nikhil handles all the important work of actually being the domain expert, I take care of pretty much everything that nobody else wants to do.
Thank you so much for coming here and being part of our masterclass. So the idea of today's masterclass is to talk about wills, the importance of estate planning, and how Yellow is enabling the making of wills through tech. How it is making it accessible to the masses. And yeah, that's it. There are just quick four simple questions we have, and let's take it up from there.
Perfect.
First and most important, what is a will? Why is it important to make a will? How do people think about will in India? What is the mindset people have towards it?
Sure. So if I have to pick up saying what is a will, right? As in, simply put, it's a statement or a document which clearly lays down saying who are you, what are your wishes, who are you, what are your assets, how these assets needs to be distributed to your loved ones. Could be family, non-family, charity, whatnot, right? That is something which a will as a document kind of give you a quick few bullets of saying these are how my assets needs to be distributed when I'm not around. The important point is when I'm not around.
Okay, and it will be active only after a person has died.
Absolutely, right? So that's the way we look at what a will is. While I said it can be in a piece of paper, law also says that an oral will is also something which is valid.
Okay. That's interesting. I always thought that there was always a confusion because people would, obviously derived by the whole movie knowledge where, there needs to be a paper and people sign it and there has to be a witness. So there are some misconceptions around will. If you could maybe give us some misconceptions and, do a fact check for us.
Sure. No, so you're right. In the sense, movies has always had the tendency to kind of exaggerate things, and otherwise there's no TRP, right? And therefore you need viewers to come and see saying, oh, this could happen, and therefore wills, trust and other things have been extremely exaggerated, saying the ultimate control being given to the trustee or the executor, saying now you guys are all in my control, I'll tell you how the asset.
Somehow the executor always comes into picture if there is like some big business empire. Absolutely. And all. You never hear or see a normal person talking about a will or what happens after that person dies and what happens to his or her assets.
Yeah, that's what makes a lot of people think that if they are a normal person, that a will doesn't apply to them, or somehow they don't need one because it's only for the kind of people that you see in the movies who have these big business empires and bunch of lawyers and stuff like that. But really the problem that India or Indians face is that a huge quantum of assets is lying in unclaimed accounts, right? So something like 1.5 lakh crores of assets are lying in unclaimed accounts across banks, mutual funds, insurance companies, PF, FD, etc. And these are all assets that have been earned by hardworking, normal, average people, which goes unclaimed because people pass away and their families don't have information as to what the assets were that they held and how to go about recovering them. So that's the main function actually of a will, is a way of giving your family the right information at the right point of time so that they can take action and not have to suffer loss in transmission or not figuring out where the assets are or going through a painful recovery process, which are all very much a reality today.
So is there any right age to make a will, or can anyone and everyone make a will?
See, the law clearly says that anyone above the age of 18 can write a will. So therefore, really there's no age bar with respect to when a person can write a will. But logically speaking, if you were to go down to say who are the right people to kind of create a will, is that when you start creating assets, that's the right time you start looking at saying what happens to these assets when you're not around. It could be a simple thing, right? Simple questions that come our way is that, hey, listen, I don't have any assets. Then asking few questions like, do you have a bank account? Do you have certain investments? You could have some, for women, you may love your bag, shoes, whatnot. These are something which you want to give it to a specific person who you may want them to, they may value this much more than the others, right? So your wishes could be anything, your assets could be not fully need to be financial, right? So when you have certain assets that need to be passed on to your loved ones, that's the time when you start creating it.
I guess the first step in this is first documenting what you have.
Absolutely.
I'm sure there will be instances where you are not even aware of this is there and you've completely forgotten about it.
So that's a perceived hurdle, right?
Yeah.
So that's why, why is will as a practice among Indians not very popular? There are multiple reasons, one of which is the idea that, okay, I have to get all my information together before I go and start making a will.
That itself is a big challenge.
Which in the offline way of making a will, that's how you have to do it. You have to gather all the information together, go find a lawyer and sit down with them and go through it. So what we're trying to do is make that process more, flexible and easy for people to kind of do it in stages, baby steps, and not have to do the whole thing upfront.
So Yellow, the platform which you have created, it's a legal tech platform where you want to make it easier for people to make wills, and you have some other services also which are mentioned on your website. So how did you come about with this idea, and what's your process to make the whole process of will making and estate planning easier for individuals?
Sure. I think the idea sort of came about from sort of two of us identifying that there is a gap amongst people below the HNI and ultra HNI bracket in India. If you're in that HNI and ultra HNI bracket, generally your wealth manager or your lawyer or your advisor, CA, somebody will tell you at some point, hey, you need to make an estate plan, whether that includes a will or a trust or some kind of tax structure for your foreign assets, etc. Right? So those people are well taken care of. Where the problem lies, which goes back to the 1,50,000 crores of unclaimed assets, is everyone below that, right? So we came up with the idea of Yellow to solve for that population, right? Starting with mid-market and looking at, is there a way that we can build a platform that's secure, that's easily accessible, user-friendly, affordable, and private, and so people can sort of use it at their own time, on their own terms, and create a will that reflects what their wishes are for their family.
So as if I come on Yellow, what do I need to do if I want to, let's say, I first want to know what I have to do, and then how do I start about it? Is it completely online? Who are the people I could speak to?
Yeah, so there's a couple of ways in which you can engage with Yellow. So if you are the kind of person who likes to DIY everything in your life, including your financial planning, etc., you can just download the app or go to the website, start creating your will right off the bat, add in your details about yourself, your assets, your family members, your wishes for your assets, and then important information regarding your executor and guardian. And the way the app and the journey is designed is that it takes you very naturally through these steps. So you don't ever have to be confused as to what do I do next. You're naturally sort of guided through stepwise to put in all the information that's necessary for you to complete your will.
See, the point that we try to kind of address here, right, is that, the initial question that you had with respect to what is the misconception of society, right? There are three broad points that we need to first look at from a misconception, or rather, why people are not creating wills. One is that, the point that there are misconceptions with respect to aspects like nominations. You believe that I've done my nomination and therefore it's great, and therefore nothing else needs to be done. But the unfortunate fact is that nominee is just a trustee. The nominee is not the actual beneficiary of the asset. Of course, there are exceptions to it. There are very few asset classes, but most asset classes, nominee is not the actual beneficiary. Second is that people believe it's obvious that assets will go to, if I'm not there, it'll go to my parent, my spouse, children, whatnot. But it's not really obvious. It's the Indian succession law which kind of comes into the picture with respect to what happens if you don't write a will. The bottom line of the fact is that in India or across the world, people can die only in two ways, which is one with a will or without a will, right? So if you die without a will, then your jurisdictional succession law kind of gives you parameters with respect to how the assets can get distributed.
But if you have a will, it supersedes.
Absolutely, that's the whole intent. Even the laws also says that if you don't have a will, this is how you need to look at it. It starts with saying if you don't have a will. So if you have a will, obviously that's the vision that comes into the picture. Now, why I brought out this point is that once these two aspects are made clear to the user or to the Aam Aadmi, if I were to tell, then it becomes very obvious that it's a no-brainer. I need to make a will, but still people don't do it. The reason is that there's a lot of friction points. The point that Niranjan mentioned, you need to take the entire assets, go sit with a lawyer, create various other aspects. What we have done is that once anyone is ready to make a will, the other entire aspects of the frictions with respect to cost, time involved, the documentation collation, all those processes are something which have kind of brought down to almost zero.
Yeah.
And that's what the platform does.
And to sort of bridge the gap between offline and completely online, we have a team of legal experts and estate planning experts in-house. So if you actually need guidance or if you need any input as to what you're doing is right, if you need reassurance, or if you have some complex situation which you think you don't know how to input that information well, you can always talk to one of our experts and they can guide you through it. So we have both for a person who's comfortable doing it by themselves or a person who needs more guidance in terms of creation of the will and their situation. We have both options available.
How long does it take for a person to create a will? Once they have decided to come on your platform, they have signed it.
Yeah, so Nikhil always says you can do it in 5 minutes, right? So
I've got mine done in 5 minutes, very honest.
So for the average, let's say a person who doesn't have too complex of a situation, maybe a bank account, some personal effects, FD, insurance. So let's say 5 to 10 assets. You really can do it that quickly because if you know kind of the asset information, if you know the information about the assets, using the platform itself is very quick, right? Of course, there is a step at the end of where you have to actually physically sign a will because in India, digital signature is not yet valid for wills. Okay. So we are hoping that, and we're trying to push, lobby for the inclusion of digital signature into wills because digital signature is available in everything else, pretty much all other aspects of our lives in terms of contracts.
So technically, you basically take once you made it ready, you take a printout, you sign it and scan it and upload.
You sign it. So we have a couple of processes that happen post that where you can video record yourself signing the will and witnessing it so that it just closes the loop and ensures that once you're done and your will is complete, you also have the additional safety net of having the video recording there just in case any challenge were to come up in the future as to whether this is the
See, the idea in which why we have put in all of these aspects or the ecosystem together is that you have an option to write a will in one sheet of page and make it legally valid by signing along with the witnesses. Is it a good will? The answer is no. Right? It may not really serve the purpose. The point of discovering assets and all of those kind of goes out of the path when situation arises. So what we have done is unknowingly we make the user, when they go through our journey, you come out with an extremely robust will.
Very detailed, the list of all what is should be part of the will, which
it is about details and planning for contingency. We kind of, our experience that we have in the last so many years of being in this space, we have kind of distilled all that in the overall journey and available to mass market at a much affordable price.
So now I will go back to how from Strata's point of view, how we would want to understand the whole process of wills and estate planning.
Sure.
Lot of Strata's investors are real estate investors, not just with investments with Strata. So what does Strata do? We are basically a fractional real estate platform where we enable people to invest in commercial real estate. I guess it was you guys who mentioned earlier that most of the disputes which happen in the country today are because of real estate matters. The litigations are around it. So wanted some inputs on elaborate the importance of will making for a person who has real estate investments, not just with Strata but otherwise also. What should they think about when they are making a real estate investment after the investment has been done? What all should they take care of?
No, great. So one point that I would like to highlight before we get to the whole hygiene of how to keep real estate much more easily accessible to everybody else is that the 1,50,000 crores that Niranjan mentioned
Hmm.
about is only financial assets that we're talking about. It doesn't include
It does not include any physical real estate,
Real estate,
assets which are person.
Definitely a much bigger number. It's
and
difficult to.
and really it becomes really difficult to not really quantify it, because how do you even quantify it, right? If there's a open land, you may know the owner, may not know the owner. It's only the title deed, and at some point when digitization of all of this happens, probably
I think it's a long way
Exactly.
for us to reach the stage for the way we've reached for financial instruments to for us to
Correct.
reach the real estate in that.
Yeah.
But having said that, one of the painful points of recovery of assets post demise is also real estate, right? The reason being that is that one, law doesn't say you need to register a will, right? Law says its registration is optional. But when it comes to real estate and when you want to transfer the assets go to sub-registrar's office, the first thing they ask is give me a register.
Okay, so you're saying a will, law does not say that you need to register a will, but while you are going for transfer of assets, they want a registered will.
As real estate.
It's easy.
Only real estate assets.
Real estate, many scenarios, the sub-registrar just says, give me a real estate, that's when I'll start doing the mutation and go to each of the authorities, right? So that's one bigger concern, and therefore one thing that we usually recommend all our clients is that if you have real estate, it's a good recommendation to also have a registration of your will. That kind of smoothens the one step of getting things done. But going back again, saying that why do I say that real estate becomes the most difficult asset class to kind of transfer is one, to move title, now you're dealing with regulators, right? Which would mean that they can ask you the host of the details, because there's an option of nomination for financial assets which is not available for real estate per se, right? You have a title deed, and the title deed could say either a joint holder or a single owner. Joint holder doesn't mean again that the other party is the automatic owner. No, the person who passed away, his or her share still needs to be distributed either by way of a will or as per Indian succession.
Okay.
Right? Which would mean that there's still activities that needs to be done, and for which you need to go to the sub-registrar, you're going to go to BBMP, municipalities, etc. to do all those asset transfer process, and therefore the whole process itself becomes extremely cumbersome, right? And it takes time and money, because when you don't have a will, you need to get, depending on the jurisdiction, a succession certificate, inheritance certificate. In Bangalore, you would have heard of family tree and whatnot, right? So each of these certificates that to be procured, you have one professional fee and court fees is to be paid before, and time, right? And then time usually takes anywhere between 3-4 months to a few years before you can get copy of those deed, document to say that now you are the legal heir. Then go to the real, each of the authorities to say now transfer.
Got it. And for you to create any of these documents, first thing you need is a registered will.
No, so this is without a will,
Okay.
right? With a will, with a registered will, you don't need to do all of this.
You can bypass a lot
Bypass
of that.
all of this. And
So I don't need an inheritance certificate.
Nothing,
I don't
nothing.
need those things. I don't need to show.
Because you name the beneficiary in your will.
See, the whole aspect of getting these documentation is the government or the court is now saying these are the legal heirs. Because without you showcase, because I can go up and say I'm the legal heir of this property, but tomorrow if somebody else comes in and say, hey, I'm your sibling, or say for whatever reason this property was promised to me, you could have many other situations, right? To kind of crystallize these are the legal heir, the government issues a document which has various nomenclature. The good part with you guys is that you're fractionalizing it, digitizing the whole process, and therefore you don't need to go to sub-registrar to transfer.
We don't need to go to the sub-registrar. So for that, what we have done at Strata is that after an investor has invested with us and after they've completed the process of investment, we nudge them to have a nominee for every investment of theirs. So we are not required by law to have a nominee, but we, as a good practice, keep on asking our investors to do that, because honestly, our target audience is 48 is the average age of our investor, but we have a lot of investors who are 65 plus. So we realize that this is going to be extremely critical. So for them, if the nomination is done, it becomes easier for us in case of any death for us to move forward. Otherwise, then we do transmission of shares, and I think we follow the Companies Act, whatever is prescribed over there. But definitely is useful for our investors to not just look at the investments they have done with us, but even the other real estate investments which they are doing in general.
Yeah.
And you guys are better placed to answer this, because if you could look at any average Indian, real estate becomes the bigger chunk of your
Today, 50% of India's household savings are in real estate, physical real estate. Most of that investment is in residential real estate. We are working towards, asking them to move their savings to commercial real estate, which gives them better returns.
Right.
And honestly, for us, it's a lower ticket size. They have exposure to a much better class of real estate. So I've heard about this, that a lot of people gift real estate, and wanted to know more about that, and how does it compare versus making a will for your real estate investments?
It's a great point, right? So Bangalore, each jurisdiction, right? Today you look at usually when any individual HNIs, ultra HNIs, or even common when you look at transfer of assets, they also look at gift as a mode of transfer.
Yes.
Right? And the point I'll come to of stamp duty subsequently is that gifting in our mind is a good option, but not an option that you should use it full-fledged. You don't want to be the next thing.
If I what do you mean over there?
So I know I just threw it in. You would have heard of the Raymond family, where
Yes.
the senior Singhania kind of gifted all his assets to the son. Now he's fighting the legal battle to get access, because he doesn't have access to any of these assets for his livelihood, right? Which essentially comes to the point that by gifting, you're losing control of assets.
And why would you resort to the mode of gifting to save on stamp duty?
No, so usually they do this so that families have access to the assets immediately, but realizing the fact or not realizing the fact that you lose control, which would mean that tomorrow you are at the beck and mercy of your children for you to be taken care of if you gift entire assets. Gift portion of it, which can be done, and the rest can perhaps come through a will, because there you have complete control. And the on post demise, like you said, is when
The assets move on to
Correct.
the success.
Now, the reason why I spoke about this is when you gift, especially for real estate, many jurisdictions have a lower stamp duty rate, but effectively there is still a stamp duty rate on gift. While income tax, there is an exemption for gift with relatives, but for stamp duty there's still a stamp duty levy, right? For Karnataka, it's very low, nominal 5,000 rupees, but other jurisdictions have 1-2%, etc. Though your conveyance will be say 7-11%, right? It'll be a much lower rate, but it's a good cost to pay. So when you gift, you have to still pay that cost and transfer the asset, right? And this again becomes relevant when you give to a non-relative. You have income tax as well as stamp duty cost. By doing it by way of a will, you end up not paying tax if it's a non-relative. For relatives, of course, there's no tax. You'll also save on stamp duty, because there's a clear exemption under stamp laws as well as income tax laws that if you receive any inheritance from relative, non-relative, no matter who, it is fully exempt.
Got it. Oh, that's a very interesting point. I think a lot.
And it also comes into the picture if you create a trust, right?
Yeah.
So if you're a person who has created a private trust, you transfer assets into a trust. Especially for real estate, willing the asset into the trust is the way to go about it, because it prevents stamp duty from coming into the picture. Whereas if you just transfer the asset into a trust during a lifetime, you end up paying stamp.
So in the will, if you're transferring into a trust, there is no stamp duty.
Yeah. So usually what happens is that at least for your user base or your audience, essentially HNIs, when they create a trust, our usual tendency is to evaluate how the asset transfers happen, which could have a combination of movable, immovable assets. Movable assets can easily move. Real estate, like Niranjan said, you break into either 2 parts or 3 parts to say the place you are living, probably you're not going to sell it. You may not want to incur stamp duty to move it into the trust because there's a stamp duty cost. Move that into a trust by way of your will, right? The other assets could perhaps, you could take a call situation. I have a client who knew that his assets are going to get contested once he's no more.
Okay.
So how to secure it so that his family gets full access to it without any litigation? He paid the stamp duty cost upfront, bit the bullet, paid the cost, moved into the trust, so that once he have clear title, he can move to the trust without any concern. Right after that, the trust now dictates how the asset needs to be dealt with. You can't contest it by way of inheritance.
Got it. No, this is very interesting. So do you guys also provide services for estate planning through your platform?
That's our blood and saying bread and butter, right?
Apart from just making wills, you'll also advise if anyone is looking at any estate planning advisory services, how to create a trust, how to go about with it.
Not only advise, we implement it also.
Yeah.
So you would also help them make a trust and transfer their assets to a trust. Look at the timelines and also look at it from a taxation point of view.
Overall, right? Not only tax. When you look at trust, especially for larger families, we are looking at situations of inter-domiciliary situations. Also, you have kids abroad. Jurisdictions like your US, Canada, Australia have estate duty implications. How do you plan for it with assets in India? All of those comes into the picture, and especially since I know you are kind of diverging into a different aspect here, we also advise on saying how do you keep it asset light when your kids know that they are settled abroad, they don't want to come to India. How to make it more light, more liquid. I think real estate to still have exposure to it. I think situations like yours will really help.
Want such kind of investors to invest in fractional
Absolutely.
real estate. Where
Because it's much more liquid.
where they don't have to worry about taking care of the asset
Absolutely.
over here. Not
That's the biggest
Yeah.
pain point. Why I'm bringing this point is that we have seen, younger generation of various HNIs who have said that if you don't do anything about it, I may even give away these assets because I don't want to take the pain of it.
true. No, today asset management is a very big pain point,
Yeah.
and that was something which we identified. Honestly, today 15% of our investor base is also NRIs.
Yeah.
They want exposure.
I'm not
to India.
surprised.
They want exposure to India. They do not know where to go.
Yeah.
They do not have the bandwidth to sit and manage a physical property in
Yeah.
India, and that's why for them this has come out to be a solution. So I think, guys, this was great. I think this was very useful. We've covered why a will is required, why a registered will is required for real estate. There are a lot of advantages of having a will. How should you plan for your estate? When should you plan for having a will? And guys, these guys have a beautiful tech platform which enables you to do all of this on your own, DIY, with a host of experienced professionals helping you. Please do check it out. Thank you so much, Niranjan and Nikhil. Yeah, that's it.
No, it's been a pleasure for us to be part of your masterclass really, and good to share our experience in this space and educate the audience more.
I think probably we should make history by the first will to include a fractional real estate
Definitely.
asset should be from a Strata customer.
No, definitely we should work on something of that sort. We want to roll out yellow to all our investor base. At least get them on this journey if they've not started it yet. Okay.
Perfect.
Thank you so much, Nikhil and Niranjan.
Thanks for having us.